Polly, among other things, is the author of the book Eradicating Ecocide, and is really the brains behind an international campaign to really create the 5th International Crime Against Peace, a crime that would hold people responsible for destruction of the earth, something that I'm sure all of you are concerned about. The campaign has, we've heard wonderful things about it, all the different ways in which this has been brought to the attention of an international audience, everything from moot arguments to some amazing media coverage to recognition from luminaries like Vandana Shiva. Without further ado, Polly Higgins.
Oh, thank you very much. Well, thank you. It's an absolute delight to be here today. What I'd like to do is before... Oh, we've got some nice birds. Before we actually turn to the slides, before we try to get the slides up, I can tell you just a little bit about who I am, where I've come from, and how I've kind of gotten to this stage. So I'm a barrister, and I was practicing as a barrister in London. My area of law was corporate law, not actually environmental law, and employment law. And one of the things that I was seeing when I was representing both employers and employees in court was that I was meeting very good, intelligent people who were very much in the business, especially huge corporations, of making an awful lot of money out of damaging and destroying the earth. And this left me with a slight quandary. How is it that we end up in a situation where good people find it completely normal and acceptable to cause mass damage and destruction? And that, for me, was really quite a driving issue in all of this, because I realized quite fast this was not about saying, it's the evil corporations over here, and here are the good guys over here. Not at all. If anything, we have, good people in all different sectors of life. And what I realized was that, in fact, if anything, law has created a framework that has normalized it, that we can create profit out of mass damage and destruction. So that really led to one of those kind of moments that we sometimes have in our lives where cognitive dissonance kind of kicks in. There's that sense of, what I'm thinking isn't quite equating with what I'm doing here. And that rub that happens in between. And it led to a very kind of seismic moment in my life when literally I was in court one day, and I looked out of the window, kind of like we are here today, in this building at the Law Foundation of British Columbia. And I looked out to the world and wondered, here I am representing a man who's up on a case that I'm his voice piece for injury and harm, psychological harm that he suffered in the workplace. And yet, as I look out the window here, here's the earth. And the earth has been suffering harm. Something needs to be done about that. The next thought actually changed my life. What I thought was the earth's in need of a good lawyer. Now, as a barrister, what it came down to was me looking around to see, well, what are the tools I need if I was to represent the earth in courts? And of course, as a barrister, my tools are laws. And I couldn't really understand why it was, if we had a huge body of environmental law, that we were increasingly escalating in the levels of damage and destruction. For me, environmental law clearly wasn't working sufficiently if we were on a mass trajectory that was creating ever more damage and destruction on a daily basis. So this really led me to think about, how do we create a legal duty of care for the earth? And that was a journey that started 7 years ago. And I thought I'd take a year out, and I'm still on my year out. And I guess I'm never going to stop taking that year out until I'm satisfied that we have the laws in place that put people and planet first. Because because I think that's really what this comes down to. So one of the things that drove me was once you identify a problem, then, as I was subsequently told later, very often those who identify the problem have all the tools required to make the solution. I started looking to see what lawyers were out there creating the new Earth law, as I saw it, a body of new law that was required here. And I looked around me, I couldn't find anyone. And I sort of went round and ended up coming back to myself and thinking, okay, no one else is going to do it, I'm going to have to do this. I'm going to have to work this out. So my starting point was really to go back to first principles. And I guess the lawyers in this room really understand that very well. As lawyers, that's what we do often, is we go to the evidence, we go to the hard facts, we go to the first principles. And to examine what is out there already. And of course, when you're looking at environmental law, and there are over 500 pieces of international legislation on it to start with, it seems like an absolutely mammoth task. Very quickly, what I discovered was that, in fact, environmental law is largely predicated on two premises. One is fines against the fictional person, the corporate entity. And I came to the conclusion that fines are essentially catch-me-if-you-can laws. Because, of course, when it comes to fining a company, the problem is that most often it is the community that's most adversely affected, has very little money to litigate. So, and it can take a long time. Aha. Wonderful. Thank you. So that was number one, that fines aren't working to slow down the process or even stop it. If anything, a company can litigate and if need be pay out at the end of the day, but continue with business as usual. And two, the second issue was what's known as the Jevons Paradox. Jevons was a gentleman in the 19th century who came up with a theory that's been borne out that where you create permits, where you try to limit something, in fact what happens is it escalates rather than dampening it down. A very good example of how this kind of plays out is with permits. So we often use permit allocation, pollution permits, which often begs the question of whose interests are being protected here, people and planet or the polluter? It's the polluter who gets the permit to pollute. And of course what happens is you end up giving out more and more permits as more and more companies come along. So ironically, you're not keeping it there. In fact, you're allowing ever more to perpetuate. And we see this with the automobile industry. So we create ever more energy efficient cars so that we can drive further and we can have more cars. So in fact, the emissions escalate. So my thoughts were very much around, well, just as I as a human being have a human right to life, how do we create a right to life for the earth? What would that look like? Is that possible to create earth rights? And more than that, if we have an earth right to life, because after all the earth is a living, breathing entity in itself, then how do we actually govern that right to life? After all, my human right to life is protected on a one-to-one by the crime of murder or homicide. And if it's myself and my community, then we're looking at the crime of genocide. And that gave birth to the idea of an international law of ecocide. Now, there are already crimes against peace, what are known as international crimes against peace. And crimes against peace act as umbrella laws that cover the whole of the world. They're principles of universal validity, and they underpin the prohibition of the most serious crimes of all to civilization. So this is a kind of universal outlawing. So for me, creating a law of ecocide was about sitting at that level, something that has to supersede what we're doing here. Because one of the things that struck me when I was researching the problem, so to say, why is it that companies are perfectly comfortable with creating great profit out of damage and destruction was that, of course, it is the law to put profit first. It is the law for CEOs and directors, their number one legal duty is to maximize their profits to the shareholder. So in fact, people are being shoehorned by dint of law already. Law has inadvertently caused us a huge problem here. International crimes against peace, of course, supersedes that legal duty. And that's very important. But more important than that, international crimes against peace are based on morality. In fact, all criminal law is a way of governing society, taking a moral imperative and placing it into a legal imperative. So just as we have the law of theft so that people don't steal, GBH, grievous bodily harm, so that people don't keep on smacking each other, and of course the law of murder. So this is about using criminal law very effectively at an international, global, universal level. We already have 4 crimes against peace, international crimes against peace. So we have genocide, war crimes, crimes against humanity. And the most recent that's been agreed is crimes of aggression. And what I'm saying is, in fact, these are really about well-being of human life, but we can extend that to the well-being of all life and add a 5th international crime against peace, and that's ecocide. So what this is about is expanding our cycle of concern, not just human-to-human engagement, but human to all beings. And that's very important when we look at the sacredness of life, because at the end of the day, we destroy our earth, and we destroy our ability to peacefully enjoy the earth, and our ability to live in peace. Now, the Rome Statute was ratified in 2002, and that codified the international crimes against peace, and it also put in place what I call a very important piece of hardware, and that's the International Criminal Court, where we prosecute the most serious crimes of concern to the international community as a whole. This, to me, is a very important piece of hardware. Prior to the International Criminal Court existing, we had only situational specific courts were put in place. So the Nuremberg tribunals, war tribunals were put in place after World War II. But once those prosecutions were ended, it disbanded. Likewise, we've had Rwanda and Yugoslavia. And there was a recognition that actually it's too late to go in after the event, that we need something in place that's there so that in fact we can move far faster rather than waiting for it to play out on a huge mass scale. Now, the International Criminal Court is not a perfect beast by any amount of means, but it does provide a very powerful disincentive. There are only 4 courts in the International Criminal Court building, and when you're dealing with international crime and nearly 2,000 cases are referred there every year, clearly it's in need of expansion. Or as one proposal that's been put forward by lawyers in America is that there's a form of decentralizing it, maybe a preliminary ruling, and then outsourcing it into neutral countries to continue under ICC rules to hold international criminal cases. It is a court of last resort. So of course the ICC doesn't step in unless a country is either unwilling or unable to take action on its own ground. So this is about also for me, when I was researching this, that we have certain elements of pre-existing hardware here that we don't have to invent, which allow us to move very fast by creating an international crime of ecocide. We already have a United Nations. Again, not a perfect beast, but the intent is to unite nations and represent we the people. In fact, the very first words of the UN Charter start with those words, we the people. Not we the heads of state, not we the businessmen or women, but we the people. So the intent is that it's actually representing the people of the earth in the attempt to unite nations. Now, of course, like all pieces of hardware, they often need an upgrade. And I do believe that United Nations is in desperate need of an upgrade. But more than that, this is about putting in effective software so that cogs can turn. We already have an International Criminal Court. We already have crimes against peace in place. And we already have the right to life as a principle that we understand under the Universal Declaration of Human Rights. So why do we need an international crime of ecocide? Well, figures were something that I started to look at as well. 100 living species become extinct every day, and that's escalating. 2 million tons of toxic waste are dumped every day. 200 million tons of oil are being extracted every day, which is giving a non-con impact with excess greenhouse gases. And in fact, we're looking at now 100 million tons of greenhouse gases are released every day, and it's escalating. The Economics of Ecosystems and Biodiversity report that came out at the end of 2010 did a very instructive number crunching exercise on mass damage and destruction to the earth. And they looked at the top 3,000 companies, corporations in the world that are now being named the carbon majors of the world. And what they discovered was that in the year 2008, the damage and destruction to the environment came to, at a very conservative figure, $2.2 trillion. 2009, it was expected then to be looking at $4 trillion. 2010, it's thought that that will double again. So somewhere we're going very wrong. We're escalating at an ever-increasing rate, up and upwards, rather than slowing this down, which suggests that existing environmental law and international environmental law is not working. And we're needing to change this. We're needing to close that door. In fact, Sir David King, who is the ex-chief scientific advisor to the British government, I went public last year saying the 21st century will be remembered as a century of resource wars. We've already had Darfur for water, Iraq for oil, and that there will be an era of ecocide here, where what we're doing is, if you imagine the earth as a pot of gold, all we're doing is we're busy taking out. And very soon, that pot of gold becomes empty. And as it becomes increasingly empty, we go to war over the very little that remains. What I'm proposing is, instead of taking out of the pot, we put back in. So this is about the problem being we've created a hermetically sealed cycle of damage and destruction, which I call ecocide, which leads to, amongst other things, resource depletion, which leads to conflict, and therefore war, and therefore more damage and destruction, and it starts spiraling onwards and upwards faster and faster and faster. So this is about not slowing it down, but halting it, cutting it completely. And I believe we can do that. And as a law of ecocide, it is the legislation that can be required to do that. The word itself has actually been around since the 1970s. All I'm doing is giving it legal definition. And this is the definition that was proposed into a fully worked up document that was submitted to the UN Law Commission back in April 2010. And the definition I gave is the extensive destruction, damage to, or loss of ecosystems of a given territory. I say there are two types of ecocide here. There's human-caused ecocide, or there's naturally occurring ecocide. And I'll unpackage that a little bit. I go on to explain that this is it's a peace provision. It's about actually such mass damage and destruction causing a reduction in our ability to peacefully enjoy our world. And it's not just humans, it's also all other beings. Because after all, if you look at any given territory, it's not just humans that live there. So this is really about identifying two different types of ecocide that can and do impact on our lives. The first being human-made. So mining, fossil fuel extraction, fracking, deforestation. These are all ecocides that you can actually, point at and say, okay, we know that this is going on. It's corporate ecocide. You can identify the individuals who are very actively engaged in this. In fact, just 3 weeks after I submitted my proposal into the UN, we had a real-time ecocide playing out, and that was the BP Gulf oil spill. And as a result, my phone started ringing off the hook with press from all over the world suddenly discovering that there was a legal proposal to make ecocide a crime. And that really changed what was going on in my life very quickly. Now, naturally occurring ecocide is equally important. Tsunamis, melting ice, floods, earthquakes, where we see mass ecosystem collapse. Now you might think, well, what relevance does that happen when we're creating an international law of ecocide? Well, two things play out here. One, there is a link between the two types of ecocide. This is a death by 1,000 cuts, corporate ecocide, happening over here, which can in turn trigger naturally occurring ecocide. So if we look at the Athabasca tar sands, for instance, unconventional tar extraction, that gives rise to excess greenhouse gases, which contributes to instability in the atmosphere, which then has a knock-on impact with melting ice because of rising atmospheric levels, which then means that the likes of Maldives ends up with rising sea levels, and their land goes underwater, and they have mass ecosystem collapse. Now, of course, it would be absolutely impossible to take the likes of an oil company to court for a naturally occurring ecocide in a completely different continent, such as the rising sea levels. That's just too tenuous a connection to be borne out. But what we can do is impose a legal duty of care, not only in the corporations for corporate ecocide, but also on governments, to ensure that they provide provide assistance to those who are adversely impacted by naturally occurring ecocide. And this is very important. So, for instance, in the climate negotiations at the moment, what we're getting is the likes of the Maldives are standing there saying, help us, we're going to go underwater within 15 years. And all other nations are turning away saying, nothing to do with us. By imposing a legal duty of care on nations, we can actually give assistance to those countries, because we really do have to have the dialogue of relocation very, very fast. This needs to be done sooner rather than later, and preempt it. Don't just wait for the event to happen. Now, I'd like to take you back in history, because I actually think there are certain things that we can learn from the abolition of slavery. What happened then is truly remarkable. Arguments were put back then and solutions were proposed that directly parallel what's going on today. And it truly amazed me when I looked back on this and researched it. Back then it was 300 companies that were either directly or indirectly involved in the slave trade. Now, either they were actually facilitating the movement of slaves throughout the world, or actually they were supplying to the sugar plantations, the first monocrop plantations we had in the world. They were very heavily worked by slavery. William Wilberforce, who was the parliamentarian in Britain, he was the man that really took up the mantle for the abolition of slavery. And he realised very early on there was no point going around everyone who had a slave and saying, do you mind using your slave a little less? That was akin to energy efficiency, because that's what really slaves were, a form of human energy. That argument wasn't going to work here. In fact, by the time he came along, over 6 million slaves had been through the system. So clearly going around everyone saying, please use your slave a little less, was not going to solve the problem. For him, this was a moral issue, that in and of itself, it was wrong. And in fact, in law, as some of you will know, the terms that are used in Latin are when you have a situation that is malum in se and needs to become malum prohibita. Something is wrong in and of itself that needs to be prohibited. So what he did was he went upstream. He realized you have to turn off the tap up here, not shore up all the collateral damage downstream where you literally have the flow of 6 million slaves coming through. But in fact, it's about the 300 companies that are facilitating the slave trade, and you close the door to the slave trade itself. He also realized something very crucial, which has really informed my work. He wasn't wanting to close down the companies. What he was wanting to do was he was wanting to close the door to those companies, making profits out of commoditizing people in chains, blacks in chains. He wanted to actually ensure that instead of commoditizing a human being, we actually treated that being as a living being. Now, of course, when he came along, industry was up in arms. They didn't want to hear this at all. And they said, you can't abolish slavery. It's a necessity. The public demanded, and more importantly, if you do that, it will lead to economic collapse. But instead, industry came up with various proposals. They said, we don't want any more laws. We already have too many laws. Let it be voluntary. We will self-regulate. That didn't go down too well. So they said, okay, we'll limit the numbers. We'll create a cap, and we can internally trade that as well. Leave it to market forces, in effect, to flatten this out. We can have tradable permits. We will tell people to use their slave more efficiently, use them less. And one particular man said, well, in fact, we will improve their conditions. We'll give them hay to sleep on as they come over in the boats. Given that 2/3 of them died in the boats coming over, it wasn't hay that was going to make the difference. But what was very interesting was that finally they conceded that, well, if we limit our numbers, you can fine us if you catch us. Catch me if you can, Ross. Now, at the end of the day, the British Parliament said no. And in fact, what turned it was something very interesting. Because there was a growing momentum. It wasn't just William Wilberforce that was speaking out. But there was one man whose role in all of this was absolutely crucial. And he's become almost a footnote in the annals of history. But he's a very important man in his own right. And during the time, he was in fact very well known throughout, well, his company was very well known throughout the whole world. That was Charles Grant. Charles Grant was the CEO of the British West India Company. They owned over half the world's slave trade. Charles Grant did something truly remarkable. He came out and said, this must stop. Now, that was incredible. From within the business itself, someone stood up and demonstrated bold and courageous moral leadership. And he stood to risk everything, all the money that he was making, and for his company as well. But when he did that, something truly remarkable happened. Government listened. Because, of course, that's the power of big business. But something else happened as well. He gave permission for others to stand up and speak out as well, from within business. Now, if we compare back then to now, and look at the difference between the days of slavery and today, the only thing that changes in this slide is the picture and the number of companies that we're looking at. The companies that we're looking at today are 3,000, so it's just tenfold. Instead, what we're seeing is industry coming up with the same objections. And instead, what happened was, we've tried all the proposals, and they haven't worked. So we tried to follow that through. So for me, I think we can learn a lesson from history here. In fact, we've already gone through that process. And what was very interesting back in the days of slavery was that it didn't lead to economic collapse. It was well managed. In fact, what happened was the British government, and then in America, and then many countries right across the world, those companies were given subsidies whilst they transitioned out of trading in slaves. So they would then move into trading in tea in China. Some of them actually became the policers of the seas, so the problem starts becoming the solution. Innovation is then found in another direction. In fact, it drove the Industrial Revolution because suddenly we had to find new solutions. And that's very important. The public responded very quickly because, of course, once you abolish something, literally overnight, the public then discovered that what was the norm has now become the exception, and of course I don't have a slave, rather than taking it as the way life is. Suddenly we have a new norm establishing itself very, very quickly. And of course what was borne out was that slavery wasn't a necessity. I believe we can do the same here by using an international law of ecocide. That in fact what we can do is make industry from being the problem into the solution. This is not about closing down big corporations. This is about actually giving the legislative framework so that big companies can reinvent their wheels and create innovation in a very different direction and be given assistance to do so from governments right across the world. Now, going back to the definition that I've proposed, what I didn't do very deliberately, because of what I learned from the slavery example, was that I didn't do a checklist of what is ecocide. It doesn't actually have in the proposal fracking, deforestation, unconventional power extraction. Ultimately, at the end of the day, what happens is if you do a checklist, someone can always reinvent around that and call it another name. It doesn't work, it's not satisfactory, and it doesn't get to the core of the problem here. So this is really about the definition. What is extensive destruction, damage to a lot of ecosystems? Extensive destruction, well, if we look at the Athabasca tar sands, you can actually see the toxic tailing legs from the moon, from satellites. They're that big. Loss of ecosystems, well, that's very measurable. In fact, an awful lot of NGOs are spending their time policing and monitoring bird life or adverse impacts and other kinds of ecosystems. But what constitutes damage? That's slightly more tenuous. Well, this was about going back to first principles, and what I was truly amazed to discover was that, in fact, we already have an international war crime that prohibits mass damage and destruction. That, to me, was really remarkable. How could it be that we have an international war crime that prohibits mass destruction, and yet, during peacetime, it's happening every single day? So, in a way, all I've really discovered is that we have a legal loophole that needs to be plugged. And the war crime is set out in Article 8.2b of the Rome Statute. And that sets out a definition here of widespread, long-term, severe damage to the natural environment. And it qualifies it, which would be clearly excessive to the concrete and direct overall military advantage anticipated. So, in essence, what this is about is that to storm the castle, if you're wiping out vast tracts of land and territory, that's clearly manifestly excessive. This arose out of, in response to the Vietnam War, because it was realised then that using agents orange, white and blue was manifestly excessive. For the very first time in our lives, we had a war playing out in our living rooms in real time. That had never been possible before. What we were seeing was mass damage and destruction on an enormous scale, which was clearly manifestly excessive. And if the door hadn't been closed to that, we wouldn't be alive and here today. So there was a recognition that we had to prohibit mass damage and destruction. Now, again, it wasn't a checklist. It wasn't about saying, okay, we ban Agent Orange, we ban Agent White, Agent Blue. It was actually recognizing that at the core of this, it is the mass damage and destruction that's the problem. Now, if we take this definition and transpose it, something's quite interesting here. Oh. Change one word, and this changes the context. So if we're looking at widespread, long-term, severe damage to the environment, that's manifestly excessive to the corporate advantage anticipated, then it begs the question of, well, what is the corporate advantage that's anticipated by extracting oil from the Athabasca tar sands? What we're looking at is a matter of just a few years, 8 to 10, maybe 12 years worth of oil, fossil fuel to heat our homes, to fire up our cars. However, if you look at the widespread long-term severe damage to the natural environment, that's going to take an awful long time to be restored. Not just 8 to 12 years, but decades and more likely centuries. Especially when we're looking at ancient arboreal wetlands and forest being destroyed. But in fact, that's not the right word to look at it in the corporate context, because whose interests are we really protecting here? It's not actually about protecting the corporate interests. In fact, the word that belongs there is community, wider earth community. So we're looking at widespread, long-term, severe damage to the natural environment, which is clearly excessive to the direct and overall community advantage anticipated. And when you look to the community, then you ask, well, who are the community? Is it the indigenous peoples living there? Is it the birds? Is it the non-human beings? Is it the land itself, the water, future generations? In fact, it's all of that and more. So then what happens is we look at it in a far more holistic context. Now, size, duration, and impact is used as the test to determine severity during wartime. So we look at how widespread, how long-lasting, how severe, and that's set out in the Environmental Modification Convention of 1977. And what's very interesting here is obviously it came about because of chemical warfare, without actually specifically using that terminology. It was recognised that if it's not chemical warfare, it could be something else that causes this. But it's actually looking at an area that's several hundred kilometres in diameter. Long-lasting is relatively short, just a season or more. And the severity, serious or significant disruption, covers three, most importantly, aspects: human life, economic or natural resources. So you don't have to have a price tag on that territory for it to qualify. And that's absolutely crucial here, because otherwise we end up just in a kind of ecosystem services pricing exercise, and it's about going a step further. International crime is very important because, of course, it levies a responsibility principle upon individuals. And this was enunciated actually at Nuremberg, where it was recognised that crimes against international law are committed by, well, said by men, obviously it's humans, men and women, not by abstract entities. What was very interesting about the Nuremberg War Tribunals was that it wasn't just generals that were put on trial, but also chief executives and directors of various companies. Flick was headed up a consortium of companies that directly profiteered out of genocide, for instance. And that's very important because that's about levying responsibility on human beings. But it goes a step further than that. It's not just the responsibility, but it's the superior responsibility. So what we're looking at here is prosecution of individuals who are in a position of superior responsibility. Rulers, public officials, private individuals. So we're looking at CEOs, directors, heads of banks, heads of state, ministers of state. That's very important here, because this is the principle known as the command and control principle. Those who are actually at the top, if you will, at the top, who are making the decisions. Very few people at the top who are making decisions that can have adverse impact on many millions further below. So this is about attaching that superior responsibility upon those who can actually make decisions that can change the outcome of life for many, many millions of people. Now, I argue that ecocide is a crime of strict liability. And this is something that I believe is very important, because ecocide is a crime of consequence, unlike genocide, which is by and large a crime of intent, where there's a decision that, yes, we want to erase a given community of peoples. Ecocide is something that arises out of deciding to make money in some manner of means, which actually, on the side, creates massive damage and destruction. It's collateral damage. So we don't have CEOs and directors sitting down in a boardroom like we are here today, saying, okay, what are we going to destroy today? That's not what this is about. This is about something that has arisen because law itself has put profit as the number one legal duty of care. Profit without looking to the consequences. Now, I'm not anti-profit, not at all. But I am looking at governing profit that gives rise to mass damage and destruction. Profit that arises out of innovation in a very different direction can take us into a completely different world where we have resilient economies built on clean energy solutions, for instance. Lord Bingham was our foremost jurist who sadly died just last year, and he actually stated it very clearly, where he said that Parliament, and this isn't just Parliament, but of course when we're dealing with international crime as well, creates an offence of strict liability because a thing is in and of itself so undesirable that it actually merits the imposition of a criminal punishment. And that's irrespective of that party's knowledge or their state of mind or belief or intention. This is very important because if we look at the Exxon Valdez scenario, what happened there was that the directors very successfully argued, well, you know, we had no knowledge or intention that anything would happen over there. And that was a very successful defense. In fact, for an international crime of ecocide, where we're looking at mass damage and destruction, surely we should know in any event, but nevertheless, it's so serious, it's on such a mass scale, that by closing the door and making it strict liability, we no longer have litigation that can play out for years and years and years, and you create an international crime that is preemptive in nature. I think before you act, provision, if you like. So this is something that actually ties in with international pollution legislation. There's an awful lot of international pollution laws that are strict liability. It's not so adverse to being in that arena, international legislatively wise, but it is actually about identifying the importance that we attach to achieving the result that we want here. And of course, when we go back to that slide that's the hermetically sealed cycle of damage and destruction, it's about halting it, it's actually about cutting it. So for me, the proposal that I've submitted is that ecocide is a crime of consequence. By creating an absolute prohibition, what we're doing is we're closing the door to a moral wrong. We're making the malum in se a malum prohibitum. And this is about levying an international crime against the natural person, not the fictional person. It's also about applying the international criminal principle of ergo omnes. When we create a new crime of ecocide at an international level, now all it needs is an amendment to the Rome Statute. We don't have to create new treaties, we don't have to create new laws around this. It's just an amendment to the existing Rome Statute, a far easier process that can be done far quicker. And when we do that, and it gets a 2/3 majority of signatories, then it will apply as under the principle of ergo omnes. So it has universal jurisdiction right across the world. And this can leverage a very dramatic shift in consciousness. That is something that happened when we abolished slavery. What you saw was that people shifted very quickly in their understanding. The norm suddenly became an exception. Overnight, people said, well, of course I don't have slavery. And what happens is that a new morality evolves. Now, the beauty is that when we look across the narrative of the history of civilization, we see that civilization gets to a certain point where we recognize that something in and of itself is wrong, and we close the door to it. just as we did with slavery, so we also did it with genocide. Genocide wasn't a crime before 1948. We got to the point of recognising the sacredness of life there and closed the door to it. And likewise with the civil rights movement, which then led to the end of apartheid, the moral imperative trumped the economic imperative yet again. And I'm saying that we can do the same here with ecocide. It's also about possibly the world's largest job creation scheme, to put it simply. This is mass global mobilization. This is about skilling up, innovation in a very different direction. It's about turning it off the tap of the flow of finance going into dangerous industrial activity, and instead opening up the floodgates to financing the solutions, the clean and green economy that so many governments talk about. And that's absolutely crucial here. What I also wanted to just talk to you very quickly about is the international trusteeship system. This goes back to naturally occurring ecocide. It can actually also apply to corporate ecocide. And this, I think, is absolutely crucial, especially in these times when we are looking at rising sea levels, and we're looking at places like Bangladesh that has kind of triple whammies playing out. You've got melting ice, you have rising sea levels, you have floods, where we're looking at escalation of environmental refugees, and that's looming over the horizon very, very fast. The international trusteeship system was set up by the United Nations under its charter in 1945, where it was recognized that we had to close the door to colonization. So if you look at maps, colonization maps of 1945, over a third of the world's land mass was actually a colony one way or another. It was understood that that had to go. We had to get rid of that system. But of course, having a country walking out of a territory that had been colonized leaves a country unable to actually stand on its own 2 feet. So it needs a period of transition, and it needs a period of assistance. And the trusteeship, the international trusteeship system that was set up was to provide administration and supervision of what were named trust territories. The language that's used here is very important, because what was recognised here was that it was about imposing a legal duty of care. So it's trusteeship principles that are applied. And it's to give help and assistance. That's set out in Articles 73 to 75 of the United Nations Charter. And it sets out the provisions there. So those territories that were former colonies were renamed. They were renamed non-self-governing territories, because that's precisely what they were. They weren't able to self-govern. But the aspiration and the intent was that they could get to a point where they could, once again, self-govern. But there was help that was required to get them there. Now, when we create a law of ecocide, this is a provision that I believe we can put back to good use. This is one of the founding pillars of the United Nations Charter. There are 6 founding pillars: Security Council, General Assembly, and the Trusteeship Council. You don't hear about the Trusteeship Council today. In fact, there is a room in the United Nations that sits 2,000 people whose doors have been closed since 1994. It's out of use because they got rid of the last colony, Palau, in 1994. It transitioned from being non-self-governing into being self-governing again. I believe we can actually put that back into good use. By creating the law of ecocide, we can open up the door to that mechanism and allow those territories that are at risk of or have been adversely impacted by ecocide to apply and say, help, we need assistance here. We've got an ecocide looming with rising sea levels, or we've had an ecocide, we need to restore our lands. And by creating that legal duty of care on nations to give assistance, we already have the hardware there that can be put to good use. All it is a matter of putting in the software. the legislation to make that cog turn once again. I also wanted to talk to you about the right to life. We have in Europe, under the European Constitution of Human Rights, case law that already states that member states have a legal duty of care to close down dangerous industrial activity that causes risk of loss or injury to life. Now this is very interesting in the context of the Athabasca tar sands, because of course, under the definition that I'm proposing in ecocide, that is dangerous industrial activity. And at the moment what's playing out in Brussels is the big question as to whether or not we should be allowing oil from the tar sands, from Canada, to come, and fuel to come into Europe. And our existing case law says that, actually, applied to that, we shouldn't be allowing this, it should be prohibited. And not just unconventional tar extraction, but fracking as well. We've got fracking looming over the horizon, in not just Britain, but right across Europe. France has actually said no to it, and we've now got a huge battle coming out in Britain. This comes back to something that, in fact, is recognised in writing, not just in law, but something that goes back, that's written from, as far as I can find in my research, back to the 16th century, and I'm sure it does go back far further. And it's called the Sacred Trust of Civilization. This is a piece of kind of moral governance that was in fact laid out in the precursor to the United Nations, the League of Nations. And this particular section was then taken forward and placed into the United Nations Charter in 1945. What it says is something that we seem to have lost track of, and I believe that, in fact, by creating an international law of ecocide, which is really moral legislation, writ large in a far wider context, that we give weight to this tenet. And of course, the United Nations Charter is the first international legal document that we have, modern legal document. What it says there is that members of the United Nations recognise that the interests of the inhabitants, and note that word inhabitants, it's not just humans, the interests of the inhabitants are paramount, so they're number one, and that we accept as a sacred trust the obligation to promote to the utmost the well-being of the inhabitants of these territories. So it's a health and well-being provision, and it's already embedded in our beginnings of international law that it applies to all of us, not just human beings. So in a way, all I'm doing is creating legislation that's taking us to a natural conclusion, a natural next step, if you will, of where we need to go. This is also about two different types of legislation playing out here. Property law, trusteeship law. Property law takes precedence today. Property law is all about ownership, I own. It's also something that can actually engender silent rights. It's not necessarily written down in law, but we're seeing it playing out. The right to destroy, the right to kill. The BP Gulf oil spill is very interesting because what happened there was not only that you had the spill causing mass damage and destruction, but the use of chemical dispersants created a double whammy, if you will, where in fact you're creating another pollution on top of a pollution. Interestingly, BP named that operation Operation Kill, and that's precisely what was going on here. It was killing that vast territory of sea, which is now identified as Dead Sea. That's about accruing the silent right to kill. That was seen as acceptable to do that, rather than looking at more benign remediation or restoration. Property law also has very limited recourse to justice. So it's the catch me if you can syndrome. we can find the companies. It doesn't really get us very far, and it takes a long time to play out, and ultimately is inherently unsatisfactory because restorative justice doesn't really come into the equation properly here. And that's by using fines. So all it's doing is protecting the interests of the few, the shareholders. It's not looking to the wider Earth community group. Whereas trusteeship law is all about guardianship, stewardship. It's looking to future generations. It's protecting rights for all. And this is about creating a legal duty of care, and a legal duty of care that comes with a kick by using criminal sanctions. This is also about protecting the interests of all, not just one particular stakeholder group. This is very much where we are at the moment. View the earth as a thing, an inert thing, which is governed by property law. And what you do is you impose a value, you put a price tag on it, you commodify the planet. You can use it, abuse it, do what you like with it. It's where slavery was. Slaveries were just things, commodities, to buy and to sell, to use and abuse. This is where we are at the moment, in a very small way. But I believe if we have a law of ecocide, then actually we can tip the balance in quite a different direction. View the earth as a living being, and you create stewardship, guardianship. That's all about trusteeship law. That's about recognising the intrinsic value in and of itself. And that's about creating a legal duty of care, responsibility, taking responsibility individually and collectively. So what this really comes down to are two very different approaches. I own the earth, or I owe a duty of care. And this is about actually using law creatively, so that in fact what we have is a health and well-being provision that puts people and planet first over everything else. When we do that, then we really can start to create the beautiful world that ultimately we all want to be living in. So thank you very much.